Hello, good day, everybody. Looks like I already got a few people here. Very nice to have you. Attorney Greg Lake, this is the Entheogenic Esquire YouTube channel and podcast. I apologize if I have a little bit of noise in the background. My wife's making some stew for us tonight. As I've previously stated, I have the podcast studio going in downstairs. We're probably a few weeks away. As far as the internet connection, now I do think my prior lives, the connection issue was due to the weather this last weekend. I don't know that for sure. It very well could be my internet provider and or my computer. So I'm ordering another computer this week. My wife's in contact with the internet provider. We're going to work on getting it up to speed. And if they can't work it out, we'll get another Starlink satellite for out here. So, doing everything necessary to, again, make this a high quality production as possible. Man, I apologize if we do get knocked off this live. As always, I'll jump straight on and do a summary video and publish it for everybody. That way you'll have, the essential information that I was wanting to get today. And with that being said, I'm going to jump kind of straight into the lesson today and discussion. And then, towards the end, I'll start looking at the comments, answer what we can, and try to keep it within an hour. I know that there's some other creators that have a live going today, and considering the emails I received, I might not be so conscious of what they got going on stuff. I'm going to try to finish it up before some of the other lives this afternoon, because I know that y'all probably want to see them, and me too, really, to be quite honest. So anyways, we'll try to wrap this in an hour, get y'all out of here, and keep going. So today, as indicated on the live scheduling thing, we're going to be talking about the text messages, these magical text messages that were produced kind of like everything else pretty quickly, which, I guess it would make sense in the timeline if it's accurate. Allegedly in the information, these messages were acquired on September 10th, whenever they were in contact with Lance Twiggs, apparently. There's some really funny things on the timeline here, and I think those have been obviously pointed out, and we'll talk a little bit about that towards the end. I watched I watched a Brian Enton. So if y'all remember who Brian Enton is, the journalist, and I like Brian, don't get me wrong. He has Brian Enton Investigates, but he's the one that did that blackface Lance Twiggs aunt interview probably a week or so ago. I know Barron covered it pretty in depth on his live stream one night. Seemed pretty incredible to me. I'll talk about that a little bit at the end, because this morning I had to go to the store with my wife, and on the way, Brian Enton had an interview with some former FBI director, and they're talking about the messages, and just, I've got a few things to say about it. And in fact, some of the stuff that they said will actually factor into our analysis today as far as looking at these text messages. So the legal issue that we're looking at today are the authenticity of the text messages. And more specifically, we're going to be looking if Tyler Robinson's defense team wants to challenge these text messages and possibly have them excluded from evidence. How are they going to go about that? What is the legal standard by which the judge will, review these challenges? And, we'll do a little bit of speculation, a little bit of legal speculation on how that might come out, what the potential remedies are, and what that might mean in terms of, would this be good or bad for Tyler Robinson's legal defense? As always, with pretty much everything we've talked about in this, we don't have all the information. So, the legal analysis and stuff we're doing will be great, and will definitely give us, kind of an idea of what's going on and what the potential outlook moving forward is. But obviously, without all the information, we can't really come to any real hard conclusions or, expectations, I guess I'd say, with regards to how this is going to proceed. But I do know, like me, many people looked at those messages and, like many other things in this case, are a little bit offended. The initial impression there is that these things are bogus. That was my thought. And, a lot of it has to do with the language, the timing. Some of the content in the messages suggests that they might not be authentic. But we will get into that. But first, what we're going to do is we're going to talk about, one, what is from a formality perspective, from a procedure perspective, what is the proper avenue to lodge a challenge like this? Okay. And so the best way to go about lodging a challenge to this type of evidence pre-trial is what we're going to call, it is called a motion in limine. Okay. And that's Limine. And what these motions in limine are, and this is, every trial court in America, state, local, federal, pretty much all rules of evidence account for this type of motion. And what it is, it's a pretrial motion where, and we'll just use this specific situation as an example, but if I'm Tyler Robinson's attorney and I want to challenge and perhaps get excluded from evidence, these text messages I'm going to file pre-trial. And, when those are filed, it's usually pretty close to the trial itself. So maybe a week or two before, usually they'll have a motion day where these motions in limine or any other pretrial motions are addressed. And then at that point, normally, hopefully the case would settle after these, for instance, like a motion in limine, whenever we're talking about these evidentiary motions and judges like, I'm going to let this in, not that, blah, blah, blah. A lot of times that helps the parties understand better their prospects for a trial. So a lot of times these things lead to settlement. Not always, but that's, part of the impetus for it is to try to give parties an even better understanding of their position going into trial. But what will happen is Tyler Robinson's defense attorney would file a motion in limine and basically be saying to judge, in the state's discovery file, they have these text messages. Okay. And, we don't believe that they are admissible under the rules of evidence. And in this specific situation, because there'd be a lot of reasons under the rules of evidence why something might not be admissible. In this specific instance, we would more likely than not be challenging it on the authenticity, basically saying that there is not a record, either documentary, testimony, whatever that is, to connect these texts to Tyler Robinson as the sender. Okay. Because in order for evidence to be admissible, it must be authentic. Okay. And, like a lot of things, these text messages, especially in this day and age where things can be manipulated. I mean, it's a magician's field day out here, right? Like Miriam was saying about the whole Charlie Kirk thing, like with these text messages too, it's magician's field with all these digital things that we can do to manipulate items, text messages, videos, whatever that is. Okay. So we have to be very, very careful in this day and age, what we're consuming and what we're believing. Okay. And that's as clear as I can see. And I think people already have that sense, but today's discussion, I think, will very much highlight that. But anyway, so this motion in limine, when it's filed, and let's say they go to a hearing and judge rules that, yeah, these things are going to be inadmissible. Now, for the state, if they want to appeal that decision, which, in most cases, if this thing does go to trial and they were denied admissibility, these text messages, they obviously would if they're going to appeal. So just because a motion in limine is ruled upon pre-trial doesn't relieve the party who wants to offer the evidence. So in this case, the state, it doesn't relieve them of the burden of having to actually try to introduce it at trial. So just because it's a ruling pre-trial, in order to preserve error, you have to actually get a ruling in the trial. So really the motion in limine is just kind of a judge previewing of how he's going to land on things. Now, theoretically, maybe you go to trial and there's more evidence than there was pre-trial. Maybe some extra testimony came out or something to further authenticate these things. Well, then judge very well could change his mind or their mind, during the trial. That's probably pretty rare. But anyways, the state's still going to have to try to move to introduce them at trial. And get denied in order to preserve that error for appeal. So motion in limines are great for many different things, but they're not a final ruling. You still have to go to trial and get that ruling within the trial, time period during the course of proceedings in order to preserve that for error. So in this situation, to the best of my estimation, where it would probably go down is in May, there's a preliminary hearing. I would need to look a little bit more at normal court practice there and probably Utah Code of Criminal Procedure to see if that's actually the proper, venue to be asserting a motion in limine. I do believe it would be the place to assert a probable cause challenge, but perhaps if this goes to trial, there might be another motion date set before the trial for these evidentiary motions. Usually it is. Usually it's a separate, individual thing closer to the trial whenever we do these evidentiary motions and things like that. Whereas the probable cause hearing is mostly just for, again, probable cause or preliminary hearing in other preliminary matters. So anyways, what is the rule of evidence that governs authentication? What's going to be rule of evidence? This is in Utah. It's under the federal rules. I would assume most state rules are pretty much all modeled against the same rules of evidence, but it's 901. Okay. And rule 901, I will read here, just the general standard for 901 states that Let's see. Here. So under 901, it says to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. Okay, so again, this is a very broad general rule here. And what we'll see, ladies and gentlemen, is that it really down to contextual, especially with things like text messages, because unless you have like an actual unaltered video of someone like receiving or sending the text message and, it's all there in the video firming up the proof, you never really 100% can prove that, in fact, this person did send this message. It mostly comes down to circumstantial, contextual evidence. And so what it is that the judge will make an initial determination of whether there has been sufficient authentication. Okay, so there's a difference between authentication and authenticate. Okay, so the judge will make an initial determination. If there is enough authentication, meaning enough factual circumstances surrounding the messages here that indicate that just enough that the jury could possibly find that these things, because the jury will decide whether it's actually authentic. The judge just does an authentication analysis, basically assessing whether there's even enough circumstantial, contextual evidence that's also admissible for the judge or for the jury to be able to come down and render a decision that, yes, these things are actually authentic. Okay. And again, it's very contextual. I'm going to go through just real briefly a few of the cases in Utah that have covered this standard. And all these obviously have to do with text messages. And what I want to do is just briefly go over some of these contextual clues that are contextual facts that the courts have previously held sufficient for an authentic, for it to go to the jury, basically, for the jury to hear about the text messages, to hear that they're alleged to have come from the defendant, and then to send it to them to actually make the judgment as to whether it's authentic or not, right? And admittedly, the preliminary standard for the state to meet here in order to get the judge to let the jury, because a lot of times I can tell you in these cases, the judge would rather just let the jury assess it. So the threshold for judge to allow it to go to the jury is pretty low most of the time. I mean, obviously the worry is that if there's just not enough blatantly contextual evidence, the fact that if the jury hears it without there being enough to really ever connect it, it could just be prejudicial, because if there's really no shot that they're going to think they're authentic, but then at the same time to hear the substance of them, that could be very prejudicial. And so that way, judge just wants to make sure that at the very least, there's going to be enough that they could connect it before he lets them hear it, before the judge lets them hear it, for the risk for trying not to prejudice the defendant in that situation. So I'm going to go over, I'm not going to read all the facts from these cases. I'll talk about just generally what the facts are, but I think as far as our analysis, if I just mention here what contextual facts were sufficient, it'll be enough for us then to jump right in and talk about what is here, what's in the information. I've thoroughly combed through the information for whatever data there is related to the text. There's not a lot. And so we'll talk about that at the end and see, well, is there enough context here as it stands to do this? And, what other, and we'll also talk too about potential further digital analysis that could be done to help one way or the other, either authenticate or inauthenticate these texts. So the first one is like a 2014 case, Otkovic. And if anybody wants like the citations and stuff, I'm not going to read them out loud anymore. Just send me an email. I can send you citations to these cases. But let's hear what the court said here. It goes, in this case, and this had to do with a robbery. And so there was like a robbery where a guy got robbed, and then it wasn't enough. And so the robber made the guy go to the ATM and like start taking more money out. Well, allegedly the robber had like sent text messages to somebody else's phone during the course of this robbery. And so what it was is just trying to connect this phone where these text messages came from to the defendant. And not only that, that there was evidence that the defendant had the phone in his possession in and around the time when the text messages were allegedly sent. Now, in all these cases, I want to say the actual evidence were pictures of the text messages. And I think here, I don't know for sure, I think in this case, that's also all they have are like pictures, or I think we were presented some kind of digital recreation or something of these text messages. So again, still a mystery there. But let's just talk real quick in this first case, Octavic, what the court found to be kind of the contextual circumstances sufficient. It says, the state presented not only evidence indicating that the text messages came from the defendant's phone, but also evidence that could support a finding that the defendant was in possession of the phone at the time the text messages were sent. So again, it's not only that, that they could connect that this was his phone, these text messages came from that number, but also they presented enough contextual evidence to suggest that the defendant was actually in possession of the phone at the time that these messages were allegedly sent. It goes on. The texts were sent from the phone number assigned to the white BlackBerry. So the police discovered this white BlackBerry in the defendant's apartment. The number to that BlackBerry was assigned to the defendant, and the defendant actually admitted that the phone was his. It goes on. It says the phone matched Hawkins' description. So this is another witness described the phone that they saw the defendant with during the robbery. So Hawkins might have very well been the victim. But it says, and the robbery occurred during the same time frame when the text messages were sent. So again, it's just all these contextual clues, right? And it's weird. It's like, I don't know if they didn't like search his phone to like see the text on there. It was not brought out here. That's kind of strange, but I do know that it were pictures of text is basically what they were offering into evidence. It goes on to say that although the defendant's own testimony that Shields, this other person, was also in the car when they went to the ATM, and that the Shields, so he said, hey, this other guy who was in the car during the robbery, he used my phone. And although that tended to contradict the other witness's testimony that this other guy had possession and was using it, the court goes, the contradictory testimony goes to the weight of the evidence, not its admissibility. So that's another thing we need to be cognizant of here is that if the state can produce enough contextual evidence to, for a jury to authenticate it, all the contradictory evidence that tend to indicate they're not authentic will just go to the weight, meaning that the judge is going to let the text messages in. Whatever evidence that the defense has that they weren't sent from him, they can also offer that evidence as a counter to the jury to what the state's presenting. And then ultimately the jury will make that assessment or determination, whether that in fact is an authentic text. And so that's also another thing that could be done here if the judge finds that there's enough context to it to admit the messages into evidence. So then we'll go into this next one real quick. This is Welsh. This one had to do real quick with just okay. This one had to do. Okay, this had to do with a guy who went into his ex-girlfriend's house. These cases are kind of fun to read. Sometimes there's a lot of drama. But apparently the guy goes into his ex-girlfriend's apartment. And this isn't funny, by the way. It's apparently he went to his ex-girlfriend's apartment and like tied her up. I don't know. I don't think he beat her. He like tied her up and scared her. And then left. And I think she went to the hospital to get checked out. And maybe he came up there and was trying to scare him too. And so, but the hospital scene kind of factors into the extraneous evidence about the text. But again, in this instance, it was pictures of the text messages taken by police. And so let's see real quick what the court here. Now, the court does say this prior case I just read is illustrative. Meaning that, this is a good example of a text messages authenticity case. We can look at the standard and kind of go by it. But the court says here, the officer testified that the photographs of the text were accurately represented the text, what he saw on the victim's phone. So we could have that here, right? Whatever officer acquired these text messages from apparently Twiggs' phone or from Twiggs will probably be testifying that indeed is what he did. And I would assume they have pictures of it or something. But if that's the case, an officer get up there, I saw these texts. Is this a fair and accurate representation of them? Yes. And so probably something similar we'll see here as far as the proffer trying to get the actual text messages into evidence. But the court says, the defendant does not challenge, it says the defendant contends that the appearance, contents, substance, inherent patterns, or other distinctive characteristics of those texts taken together. So like here, and that's another thing, is like context matters too. So I know a lot of people, including me, have an issue with the actual substance of the language. And we'll get into a little talk later. This might be why Twiggs Aunt says some things she did. But, a lot of people take issue with that language. They say these people don't talk like that. And that's been a general consensus amongst people. And so I think what the defendant, in this case, Welsh, was also trying to say is that, the context of what's mentioned, the way that the conversation goes, stuff like that isn't indicative of a text from me. And let me just back up real quick. 901, the rule has some examples of and stuff in there, like some figurative language that you can look at to get an idea of what the rule's getting at. But part of it says that, testimony that an item is what it claims to be. So like a testimony from an officer that, hey, this is a text messages of what I saw on Twiggs' phone that day. It can also include, information about the appearance, contents, substance, internal patterns, or other distinctive characteristics of the item taken together with all the circumstances. So again, it's not just that, hey, I got these from Twiggs' phone, but hey, these messages appear to be discussing this event that we're in trial here about, which these texts do. They might make the contention, this is perfectly normal, furry Discord server talk, something like that. So again, also the actual thing, looking at it, whether it's consistent with other known facts about this situation, will be relevant to this analysis. Okay. And so what Welsh, again, he tried to allege that all these, when you put all of it together contextually, it's no good. This does not indicate that it came from me. The court says, contrary to Welsh's assertion, they disagree. The state did present several pieces of evidence that, when combined, were sufficient to support a finding that Welsh authored the text. And here go the different aspects. They said, one, the roommate testified that the victim had previously dated Welsh. So I guess this is testimony from a roommate of the victim that, was talking about their relationship. The roommate testified that the victim had previously dated Welsh, the defendant, and the officer testified that these text messages were received by victim on her phone and came from a person who was labeled in her contacts as Harley, which is the defendant's first name with a Y added, is what they're saying here. Second, the phone number that sent text was listed in one of Welsh's contact phone numbers in a police database. So apparently the police went and searched their database. This number, this phone that this text message came from, that matches Welsh's phone number. Third, the timing and content of the messages supported a finding that the defendant sent them. As noted, the defendant and victim had previously had a romantic relationship, but their relationship had ended. Then, just a few hours before the texts were sent, the defendant broke into the victim's apartment and tried to tie her up, blah, blah, blah. So they're basically saying that, their relationship, I guess they had been in contact, and then maybe there wasn't any contact. And then after this happened, suddenly there's this, picking back up of conversation. And so I think that's what the court was getting at there. And then lastly, they say the text sent by the defendant to victim, the text sent by the number to victim tracked these events. In those messages, the sender expressed his love for the victim and referred to our whole relationship. So again, ladies and gentlemen, that's probably obviously something in these texts as well that the state could obviously grab onto as, saying that it provides more context to it. So again, in both of these cases I just mentioned, the court did allow, obviously, the messages into evidence. And so the last one here is kind of a weird one. It's not, none of it's funny, but it's like a landlord was kicking some people out, but they didn't leave. And so started to go through a legal process, but I guess it was taken too slow. And so the landlord sends one of his guys over there several days in a row to like collect the landlord's personal property that was there. And during the course of that, one of the girls wakes up and this dude is, touching her stuff. Is, again, not cool stuff, really weird, strange thing. But apparently, again, after the event, there weren't specific text messages sent by this guy, but what ended up happening is that the police asked the mother of the victim to text with the guy from the victim's phone and try to get him to say things that would indicate that this was actually an event that happened and that he's responsible. So again, this court refers back to the prior two cases that I just talked about, saying that, yeah, this standard works. This is the way that we do this. talking about each of those decisions was decided correctly, et cetera, et cetera. So let's talk about here what the court says. The court says that the timing of the messages is less than clear. And I think in this case, too, we have that problem. And I'll talk about that in a minute. So he's saying the timing of these messages is less than clear than in the prior case I just talked about. And says, particularly since the photograph texts do not include any dates. Okay. And so, again, Brian Enton, and I'll talk about this a little bit in a minute, but Brian Enton showed pictures of what they had produced as far as like actual pictures, not just listed information. And I didn't see any in the produced text messages in this case per se right now. So, and we'll talk a little bit more about that in a minute. But it says, but they do include the days of the week and times that, together with Detective One's testimony, that he correlated the days of the week with the dates and determined that the messages were sent between March 10th and March 15th, make it possible to piece together the timing. The message also contains details about the parties' relationship, where and with whom they live, for example, and about the events the night in question that only the people involved would have known. Moreover, Detective One testified that he photographed the text and the defendant's contact page on the mother's phone. Testimony that an item is what is claimed to be as an example of evidence that satisfies requirement authentication. And Detective One testified that he verified that the text to mother came from the defendant's phone by looking at a county document. So remember the last case, they looked at like some database. So here we go. They also looked at a county document on which Sandoval had put the same number down as his personal contact number. In light of these corroborative circumstances that supported a finding that the defendant did send the text. And so in this last case, just to clarify, this was actually a ineffective assistance of counsel case. And part of that was and hey, might have Robinson saying this, but part of it was, hey, my defense lawyers didn't contest or challenge the admissibility or admission of these text messages. But obviously, in order to determine whether, in fact, there was an effective assistance of counsel, the court actually went into whether that would have even been successful or whether a regular attorney would have done something, and obviously concluded that no harm, no foul here. Most normal attorneys would not have, done that. So with that being said, let me mention a few other things, because I know in people's heads you're thinking, well, there's other forensic data and tests that can be done to prove that these text messages, So when we're talking about that, so there's one. So the forensic, I'm assuming, could prove that at the very least, in fact, what we're looking at on Lance Twiggs' phone is indeed some kind of communication that came from this date and time from the phone that's Tyler Robinson's. But again, at the end of the day, even if you can prove that, you still can't necessarily prove that Tyler Robinson was the one that actually sent the messages. And look, ladies and gentlemen, these people lived together. They were allegedly romantically involved. Lance Twiggs very well could have had access to Tyler Robinson's phone and done it himself without Tyler's knowledge. And then things hit the fan, and, here we are. And that just ends up being, the last messages on Tyler's phone to Lance, something of that nature. But again, digital forensic analysis, from my understanding anyways, can help clear at least some of it up to really get to the bottom of, did this actually, what we're looking at, it wasn't just created on a word processor and then uploaded to the phone, something like that, but actually some kind of message that was actually punched in from, Tyler's phone to Twiggs. So again, and we don't know if there's been any of this forensic analysis done. Obviously, if there has, that's even better evidence. If it's favorable for the state, it might be favorable for the defendant. The forensic analysis might show that what they're showing us was created on, Kash Patel's word processor, just allegedly, speculation there, just for instance, right? So we do have that kind of a wild card here about if there's been forensic digital analysis done, what that's shown, what does it tend to indicate, not indicate in regards to these text messages, et cetera, et cetera. And so with that being said, I hope that's enough for y'all to kind of chew on for a bit and think about this issue of authenticating or challenging these text messages, because I know a lot of us, me included, saw these messages and thought. And before we end, or before I go to doing comments, so if y'all want to right now, if y'all want to start, if you're there and you feel like you want to throw some comments, some questions in, Now's your time. I feel good. Like we're kind of over the kind of the beef of or the meaty part of what I want to talk about today. But we're gonna discuss a little bit more because I want to talk a little bit more specifically about this case and about these texts and kind of what we're looking at right now as we speak, without any of the digital forensic data, things of that nature. Let me talk real quick about the Brian Entin. So I don't know how many people here saw Brian Entin's interview. He was actually doing, he has his own independent journalist like YouTube channel, and it's great. I like Brian Entin's journalism. He's fine. I don't think that he's out there trying to mislead anybody or anything. I think that he is just hook, line, and sinker, even though he's an independent journalist. He just kind of seems to me like really still bought into, the Fed slop narrative, and just generally still in a way affiliated with the mainstream media. Because if I'm mistaken, the interview that he did with Lance Twiggs' aunt, allegedly, where her face was blacked out, they looked like they were in some kind of office building. To me, it looked like possibly a government office building. I don't know that. That's speculation. But anyways, he seems still kind of connected to the mainstream media thing. And I think that the interview that he did of Lance Twiggs' aunt was on behalf of one of those media entities. I can't remember which one it was, but it wasn't just his normal YouTube channel. It was him and his YouTube channel, but like on behalf of one of these major mainstream media outlets. And the reason why I'm talking about this is because, right, Lance Twiggs' aunt, to the extent that she's going to testify, things like that, could help provide context to help authenticate these messages. And so what we expect her testimony to be, what we've heard her say, is obviously going to be relevant to this analysis. And, Brian Entin today on the video stated that, he got a lot of comments that people were kind of questioning him and his journalism for doing that interview. He said that he was aware and he expected those comments. He did say that he did everything he could and felt good that actually the lady was who she claimed to be. So let's talk about that for just a minute. And this takes me back to, he was doing this on behalf of this major media outlet. So, and this is just me wondering, speculating. I'm not stating facts, but I'm sitting there wondering, I'm like, with that being said, I wonder if, this big media outlet reached out to Brian Entin and was like, hey, will you interview this lady who's Lance Twiggs' aunt, et cetera, et cetera. I'm wondering if the witness came through this big media outlet, if Brian might not have been quite as thorough as he normally would be, but is still leaning on maybe the credibility he's placing in that media outlet to then say to us viewers today that, like, hey, I feel good that there was enough information to suggest that this lady is who she claimed to be. So that's just a thought that I had. Maybe she is, and maybe she is the person that she claims to be, and he feels good about it. But it just made me think that potentially maybe he might have not gone quite as deep as he usually does, because the media outlet sent her to him and, maybe represented she was pre-vetted. That's just pure speculation. But then Brian did go on to say that, some of the stuff she said, he said, look, I'm not telling you one way or the other which way to believe her or not. He said, it doesn't matter to me. He said, right to him is a little bit odd too, but he said he's still not sure which way to think about what she said. But today, Brian Entin brings on a retired FBI agent to talk about the text messages. Okay, so again, this is no one that's involved in this investigation or anything like that. But, as you could imagine, this investigator felt very confident. And here's the funny part about it, y'all, is that in the same interview, the investigator and Brian are in one vein saying that these look really suspicious. This is very kind of strange the way these are, et cetera, et cetera. And then towards the end, though, they both kind of go back to indicating that they believe them. And one thing the investigator said that really got, oh yeah, because Tyler allegedly made a statement in there that, oh my God, I don't know what my grandpa's going to kill me. He said, oh, well, that looks very sociopathic. He actually called Charlie Kirk a public official. Okay. Just so, and I know we talked about the defamation thing the other day. It's like, and not that this matters necessarily, but it's like, he called Charlie Kirk a public official. Really, Charlie Kirk was a public figure. There's, public officials or government employees or elected officials. So that was kind of strange to me, but he said, oh, well, he showed no remorse or surprise, after he just killed a big public official. This looks very, he's more worried about his grandpa. This looks like he's, sociopathic. And because this seems like he's very sociopathic, I think that makes me think these are authentic. And so it just, my take of it, again, this is just my take. I firmly, and I kind of firmly believe this. I mean, I think that Brian Enton is unwittingly being used. Again, this is my opinion, speculation. I think Brian Enton's being used who's actually a legitimate independent investigative journalist, really kind of an uninterested third party in many ways. But like, I think he's unwittingly being used as a pawn to try to shove these things down our throat, to be quite honest with you, as bluntly as I can put it. And I think that this investigator guy was part of that too. I think because the Lance Twiggs interview, and here's one thing about that interview, she's like, oh yeah, this is how they talk. Oh yeah, those furry, game players on Discord, this is how they talk. I mean, I would find it very surprising if this lady had ever, how many of your aunts have come and like looked at your Discord server, checked out your text, like checked out how you and your buddies are talking like online? Like, has they ever seen that? So that was just very, very suspicious to me. But I think because, like Brian Enton said, he got a lot of pushback. I mean, from our community too. And I guess in his comment section on that interview, he brought on this investigator who's now also trying to further push us into thinking, that these are legitimate texts, even though we don't have any real information to go on to really discern that. One thing that the investigator did say is that, he kept saying, well, there's just not a lot here. He said, I wish there were timestamps. And really what he was referring to, the reason for that is because in the text messages, there's a lot of references to like, oh, who did they catch? Oh, some guy, they had him arrested. I think y'all remember, right? Where it's like, there's several instances in there where it's like, Tyler and Twiggs would have had to been really up to speed with the rapidly changing media announcements that day, to be able to have at the time, the general time that these messages would have had to occur, right? Because it would have had to occur, obviously, sometime shortly to a bit after the actual event. What was even out in the media at that time? So it's one of those things where, I'm sitting there thinking, if they do have timestamps, it may be, it could be the timestamps might blow it out the water for the state, right? Because if those timestamps were to come in and we looked at them and were able to assess that these people are making statements that weren't necessarily even in the media, then there's no way that they could have generally known this per se. It really could maybe backfire if there are timestamps, if the state were to try to bring them in. I mean, let's say, for instance, just speculation, theory, hypothesis, that the FBI generated these things and the state knows nothing about it. But there's they find some timestamps and bring them in, and then we look at it and they're none the wiser. Again, just theorizing, hypothesizing some, because stuff's so crazy these days. You never really know. You can't really leave a stone unturned when we're thinking about possibilities in this case, right? Stuff's been pretty crazy. So I don't know if the chat is not working. I apologize if it's not, y'all. It's perfectly okay. Obviously, like always, I'll be in the comments on this video once I finish up the live stream post. So feel free to post your questions there, and then I'll either do another live or something. This seems to have gone at least okay internet wise. So very grateful for that. Thank you, Jesus. So yeah, but I think I'm going to kind of end it right there, y'all. This has gone pretty smooth. I think this went well. So I guess I'm going to end it here. Yeah, I feel good where I hate that I don't know if the comment section are working or not. I'll look into it. Two things. So I'll end on announcements here. Hey, we're like over 550 subscribers. Thank y'all so much. I'm so grateful. Man, I have terrific subscribers. Thank y'all very much. Thank you for your emails and concerns about the issue with some of these other content creators that, according to some of you, I don't know this for sure. Some of you think that they've been kind of taking my content and not attributing it to me. Um, I love them. God bless them. Look, this stuff is really easy and fun for me. I'm of the mindset that if people need to take what I've done and repurpose it and not attribute it to me and they feel good about that, then hey, that's on them. For me, I would feel terrible doing something like that. I'd have a hard time sleeping at night. So not all people are that way, and it's okay. I would just to be quite honest, I would urge any content creators like, look, if you're having issues getting some, just come, man. I've got tons of stuff. I got more stuff than I'll ever be able to report on with the Charlie Kirk TPUSA thing. I got tons of stuff. But anyways, yeah, I love everybody. I really do. I'm not gonna let drama, nothing like that. But no, thank y'all for the emails. I appreciate the concern. But yeah, I don't do drama. I don't have time to go chase these things down. And that's not saying bad about people who might have the time. I've just been very busy. I did a 2.5 hour lecture yesterday. And then I had meetings. It's been very busy. So I'm not too worried about it, but thank y'all. I love y'all. Thank y'all for supporting me, and we're going to keep rolling. Anyways, I'm going to close down this live stream. I've got new equipment coming. I'm working on even getting better internet regardless. Podcast room going in downstairs. We're going to take this thing to the next level. Content wise, I'm going to be doing some more different constitutional things. I'm going to be talking about ICE coming up, some of the ICE stuff, some Second Amendment stuff that's come up. So I'm going to be kind of branching out on some of the constitutional and legal issues and stuff like that. Just give a heads up. But I think that's cool, probably cool with everybody, but just FYI. So anyways, thank y'all very much. I love it. This went great. I love live streaming. I hope everybody got what they came for. And I'll probably be posting some other recorded videos later today. I've got a few more things I want to bring to light. So anyways, love y'all. Have a good one. I think there's another live stream going on here in about 20 minutes. Go check them out. Love y'all. Peace.